demanded tax compliance certificate by Professor Tom Ojienda from the Kenya Revenue Authority, in which the Law Society had contested after Professor Tom Ojienda filed a suit in this honorable court. The penultimate decision of the Court of Appeal was rendered on the 6th of February 2019, and that's why it's important. 6th of February 2019. My Lord, I wish to rely on the very last paragraph of that decision, page 41.
Is it here?
Yes, page 41. In the bundle. In the bundle. The originating bundle.
The first one.
Yes. That decision of the Court of Appeal, the penultimate verdict of the Court of Appeal, their lordships and their our leadership stated, paragraph 15. Accordingly, we are satisfied that the applicant, that is the Law Society, has satisfied the principles upon which an application of this nature is granted, and we therefore grant a stay of execution of the ruling delivered on the 4th December 2018 in Nairobi High Court Constitution Petition 418 of 2018, that's by Professor Tom Ojienda, and any consequential orders pending the hearing and termination of the applicant's intended appeal. The appeal has not been heard as yet. So as at the 11th of February 2019, when the counsel of the respondent was then admitting, without a tax compliance certificate, the decision to compel KRA to give that tax compliance certificate had been stayed on the 6th of February 2019. So therefore, it is apparent that whereas all the other applicants for this nomination had complied, this specific applicant, together with Nadir Rungu, had not complied, and one of the positions complied. That would precipitate a discriminatory act under Article 27(4) of the Constitution, because you have one stream complying and another stream not complying. That calls for the quashing of that decision. My Lord, the Constitution in Article 260 states who are state officers. This would be a position in state office. So compliance with tax compliance and other such conditions are set in the Electoral Code of Conduct of the respondent are a prerequisite to the compliance demanded of state officers. And therefore, going into an election with these nominees who do not qualify that opens up even that JSC's own constitution if they were to be in a particular office without compliance in that respect. Therefore, there is that danger. And therefore, my Lord, it calls for your intervention to grant leave. Let me now address your Lordship to three pertinent objections raised by the respondent and the interested parties. The first objection. They argue that we ought to have gone for arbitration because ostensibly, according to them, with respect, this is a dispute between a member and the Law Society. I beg to differ. This is a protestation about a process of election of a member representative of the Law Society to a state office. It is not, with respect, a dispute between a member and the Law Society. So with respect, my Lord, we will be splitting hairs if we were to say, let this dispute go for arbitration and not come before you as they are. A link to that is that if indeed you are convinced that this should be a dispute to go for arbitration between the applicant and the LSK, where does it leave the other members who look up to the Law Society to abide by the law, to uphold the rule of the law, and yet this applicant has sought judicial review relief? Secondly, they urge that you ought not even to grant stay, that you ought to strike out in limine these proceedings. Where does that leave Article 48 of the Constitution? My Lord, they cannot approbate and reprobate at the same time. They urge that indeed these applicants should never have inherited the test of the Electoral Code of Conduct as amended in 2018, and that Article 171 of the Constitution, as they so put it, does not demand, quote unquote, the extra baggage of these demands. The question then is, do we read the Constitution in isolation? Any judicial officer that is, any state officer that is elected or appointed to state office has to be subjected to Chapter 6 scrutiny. The LSK put these conditions in furtherance of the demands of Chapter 6 of the Constitution. Note, my Lord, with respect, no decision has been made by the Law Society to recall that decision. I'm concluding. I'm coming to my third point. My third point, the objection. The third point that they raised, my Lord, is this, that on the 19th of March this year, the AGM of the Law Society, 30th, I apologize. The decision at the AGM recalled, as it were, those amendments to the LSK Electoral Code of Conduct. Now, two issues arise. One, was there a decision by the Council to then revoke the original standing conditions for these nominees? None. None has been taken. So that then we could align the decision of the Council, as it then stood, with what as now stands. Secondly, the law of retroactivity bars that decision applying now to exempt this particular first and the fifth interested parties from the conditions as set. So those objections fail on that score. And that, my Lord, in conclusion, in exercise of your discretion, I believe that the proper forum to ventilate the grievances that the respondent and the interested parties may have to these proceedings would be at the inter-parties hearing. To shout out the ex parte applicant at this stage would be to deny the ex parte applicant the opportunity to ventilate and access justice. My Lord, we have been made aware of the existing judicial review, constitutional petitions number 83 and 84 of 2019, 93 and 94. 93, thank you. 93 and 94. Raising similar objections. My submission, my Lord, with tremendous respect to the respondent and the interested parties, is that upon the grant of leave, in furtherance of Article 48, to enable someone such as the ex parte applicant achieve justice, ventilate those same issues they have before you in that forum, would be upon the grant of leave. My Lord, if you are minded to then stay these proceedings for arbitration, then we would request for a stay of the nominations as has been prayed for in the chamber summons, and my Lord, that you find that your discretion will be properly exercised in the grant of leave to operate as stated.
I know you said with regard to what the general meeting passed,
Yes.
you said cannot operate backwards, retroactively, retrospectively, and so on. But I'm just thinking of the doctrine of mootiness. Has it not rendered some of the arguments moot, where circumstances change and there's a pending suit? What happens?
Now, two things, my Lord, with tremendous respect. When the suit was lodged, as at that time, that decision had not been rendered. Number one, that is very fundamental. Very fundamental. Number two, none of the interested parties, or indeed the respondent, have sought any relief either to stay this proceeding, pending clarification from the Council, from the Law Society itself, about that issue. And then, none of the interested parties has sought, they themselves, the interested parties, that now I stand exempted from the original standard, the original criteria under the electoral code of the respondent. So I don't think, with respect, this is moot.
My Lord, we have filed submissions which are dated, order submissions are dated the 16th of April 2019.
Yes.
Lord, we seek
I hope
convince.
they are here. Passing the final submissions. This one,
We seek to convince this court that first, there is no jurisdiction to entertain this request for leave, and even if there was jurisdiction, no arguable case has been demonstrated to warrant that leave. Lord, Article 171F of the Constitution prescribes the requirement for election of male member representative of the LSK, the JSC. It preconditions eligibility to at least 15 years experience in an election to be conducted by the body responsible for the professional regulation of advocates. Lord, under the LSK Act, that body is mandated to make decisions inter alia relating to its own elections and dispute resolution mechanisms. Lord, commencing with Section 16 of the Law Society Act, decisions of the society are of binding force only if approved by the members in an annual general meeting. Lord, under Section 41, subsection Q, alternative forms of dispute resolution, including reconciliation, mediation, and arbitration, are those envisaged under the Act. My Lord, under Section 43, subsection 3, the regulations then existing under the repealed Act are preserved.
The 1960s.
The 1962 and 1997.
They have not been updated.
Operative for these purposes, my Lord, will be the 1997 regulations, which at Regulation 2 thereof require that all disputes relating to the management of the affairs of the society be subjected to arbitration. And my Lord, you remember the act of electing under Article 171 is an internal act of the Law Society of Kenya. Lord, the requirement for a tax compliance certificate is not one that was set by Article 171 of the Constitution or one that was set by the Court of Appeal in its decision of 6th February 2019. In fact, in that decision made by the Court of Appeal, the Law Society had not sought stay before the Court of Appeal. My Lord, the requirement for the tax compliance certificate was set out in the code formulated by the Council of the LSK in 2015. This fact is manifest from paragraph 20 of the affidavit of Mercy Wambua, which is filed on behalf of the respondent. Lord, a plea is made under oath by the first interested party. That code was never subjected to the annual general meeting for approval in terms of Section 16 or Section 41. That fact has not been controverted. Lord, that notwithstanding, the annual general meeting, the decision made on the 30th of March 2019, has affirmed that the tax compliance certificate is not one of the eligibility requirements for election. My Lord, with this background fact, the primordial question that needs to be answered before we progress further is what is the effects of the decision by the AGM on the 30th of March. Lord, under Section 28 of the Interpretation and General Provisions Act, Section 28, subsidiary legislation can apply retrospectively to the date of commencement of that legislation. Having established that this code did not have the approval of the members, and that the members have now ascertained their position on the issue, it follows therefore that this is a matter that has been settled in the annual general meeting. A question may arise as to whether that is a dispute that is justiciable. If at all it is justiciable, then the avenue available to the applicant out under Regulation 2 of the 1997 regulations. My Lord, there are several decisions of this court on this particular issue. I don't need to spend so much time on them, but suffice it to say, the Lord will pick the decision appearing as number 8 in your list of bundle of authorities. Number 8, Lord. At the case of Majimbo, Juji Addis of the Law Society of Kenya. Lord, in this decision, the Sister Justice Yamwea, whilst faced with a similar issue, refused to grant leave to commence judicial review proceedings for the reason that there was, in fact, not an alternative. There is a proper forum set out under the Law Society Act for the adjudication of disputes of this kind. My Lord, on the arguability of this cause, judicial review is now determined both by common law and statute. The three traditional grounds are illegality, irrationality, and procedural impropriety. There are also other grounds that are set out under the Fair Administrative Actions Act, and it is our humble submission that the complaints by the applicant do not marry either in the realm of the three traditional grounds or the statutory grounds set out in the Act. But my Lord, with finality is the requirement set out under Section 9 of the Fair Administrative Action Act. Section 9, subsection 1 demands that a request for administrative review be made without unreasonable delay. The decision sought to be reviewed was made on the 11th of February 2019. No explanation whatsoever has been given for that delay. My Lord, under Section 9, subsection 2, the court is obliged to reject a request for review if the alternative or the proper forum has not been pursued. That is the case here. Lord, for an applicant to qualify for judicial review, he must be an aggrieved person as Administrative Actions Act, or he must have sufficient interest in the subject matter. And the question as to what is an aggrieved person is one that has been determined both in text and in case law. Lord, this is an election in which the applicant did not present his name for nomination. The applicant has not indicated how his right as a voter has been violated or is threatened with violation. Lord, like the applicant in the Majimbo case, this applicant that is not an aggrieved person, neither does he have sufficient interest. The applicant cannot allege discrimination in a process in which he did not amend himself to. Lord, the respondent received applications from 5 members of the Law Society. All of them, 5. All of them were accepted. So where is this discrimination? Lord, if you look at it from that perspective, it becomes clear that this request is frivolous.
The request for leave
is frivolous. It is vexatious. It is also an abuse of the process of the court. It is an abuse because there is already before the Constitutional Division 2 petitions, 93 and 94. It is also an abuse because the issue sought to be litigated is not justiciable. It is a matter in respect of which the AGM of the Law Society has decided. It is mute. Lord, I humbly request you dismiss this request. My colleagues will say something because we still have 20.
I thought you exhausted all your time. You didn't share.
Oh, my colleague will exhaust.
Okay. Before he shares, maybe you can answer one question.
Yes.
Quickly, the narrow question before us is the grant of leave, which is the parameters are known. Of course, all of you are going beyond to address the substantive issues which are there. But talking about leave, I know there are 2 schools of thought. Of course, me and belong to one, and tell you which one. Is leave really a requirement now under the current constitutional dispensation, which guarantees access to justice, right from Article 22, 48, 258, 22, there's all these ones saying one can approach the court. I've often asked him whether we strictly need leave and whether the 53 and Section 8 and 9 of the Law Reform Act are really relevant, but whether time has come for Parliament to look at those provisions. On one hand, we have the traditional common law jurisdiction prescribed under 53 and Section 8 and 9 of the Law Reform Act. On the other hand, and these provisions are called mandatory terms, that you must seek leave to approach the court. But on the other hand, we have a constitutional dictate saying a citizen has the right to approach the court. And I keep on saying, the party is never, and I've been waiting to hear even this discussion. I know South Africa, they have said they want one regime of judicial review embedded in the constitution. That's a citizen now, under 2010 constitution requires leave.
Yes, my Lord, our view is that leave is still necessary. And the reason is this. There is a dichotomy because between the constitutional petition avenue and the judicial review avenue.
Yes.
And in the judicial review avenue, discretion is exercised so as not to stifle administrative action. So that the considerations are much stricter than a petition. If somebody wants a last avenue, he can go for the petition. And Lord Hasbury has made this quite clear, and I don't think there is anybody who has written anything to contradict him. He says that in order to bring proceedings for judicial review, a person must have standing to do so. At the permission stage, it's only in obvious cases that the court may decide that the applicant lacks sufficient interest. So that the twin element of aggrieved person and sufficient interest are the ones that have to be interrogated. Compare this with a petition where any other person can come to espouse a claim for somebody. But in judicial review, and as made clear by the act itself, you must be an aggrieved person. So the necessity for leave is still there. That's our humble opinion. Perhaps my colleague will say something about it.
Mr. Who is next?
Okay. Yeah, very, very briefly. Just to answer that, my Lord, the reason that those prerogative orders now exist in the Constitution, and people tend more to go through constitutional petitions, answers that question, pending the repeal of what is unnecessary.
They still come here.
Yeah, but they still come.
Citing the dispute.
Yes, they will cite them, they will float them in whatever way. But when they come in a judicial review, they now face a bigger challenge in satisfying those two parameters and the Fair Administrative Actions Act. Two is because judicial review proceedings are so tight and provided for in a very particular way. You will be able to determine that if you gave leave under the chamber summons dated 25th, the decision they are seeking to challenge there is a decision of 13th February, not 11th February, which they have submitted. And they cannot amend that in the motion now to challenge a decision for which they did not grant, they did not seek leave. The prayers are to quash the decision of 13th February, and it goes all down. And therefore, if you were to give leave, it will be an act in futility. There are several decisions on that. We are just winding up. But this, when you look at that particular application and going inside, whereas on the opening page, they seek to file it in Nairobi. The affidavits and statutory statements were supposed to have been filed in Nyeri. You will look at that, you will see that either they don't know, either something is wrong somewhere. There was one particular aspect about the issue of aggrieved party my learned colleague has dealt with. The issue of where the pendency of other proceedings in a of equal jurisdiction. There's a specific decision where this court has held that where there are other pending disputes relating to the same matter, and if you look at the first respondent's replying affidavit, which attaches the other, the order sort of certiorari prohibition are the same orders sought in petition 93, petition 94. And that is why they were consolidated. And they're the same orders which are being sought here. And that issue of subjudice is what the Civil Procedure Act cures by Section 6 of a court shall not try a matter which is already pending in previous proceedings. And this is the Act. The rule 53 is under the rules made pursuant to the provisions of the Act. And therefore, if the Act says you cannot do this, it ties up with the same thing that the Fair Administrative Actions Act Section 9(2)(3) says you cannot, unless there is special permission sought and granted. And that special permission being sought and granted is what should have been considered in this leave stage, where the applicant will be coming to you to say, I am coming for a special permission other than any other permission which is ordinarily required for leave. Why didn't you go there? Why have you avoided the other cases which are there? Those are not answered. They had the opportunity to answer those, and they did not answer even after it was raised. And without answering those, it is in our humble submission that the grant of leave should be denied. And worse still, they want that leave to operate as a stay on matters which are also pending elsewhere, to be heard the day before tomorrow. And they were duly notified about that. Is it therefore that they are thinking that by some chance somewhere, a different court will give them something which they don't think they can get from that particular court? My answer is, you should not. And we urge you not to grant that leave and just clog the diary of this court with multiplicity of matters when others are already pending. It will help even in the pillar, the judicial pillar, so ensuring that you don't accommodate, I didn't want to use that word, but with a tremendous respect, busybodies. That you should not allow. That is all.
What is the standard of leave requirement? Is it not a low threshold? I'm just wondering, is it a high threshold?
Leave is a statutory threshold.
Yeah, but the level of proof, I know there are many authorities.
The level of proof
yes.
is where is actually the section 8, 7 and 8 of the Administrative Actions Act sets out the statutory parameters. But even legal authorities again put the threshold much higher. And more so, when the leave is sought to operate as a state, it then goes even much higher. We are saying they've not even met that bare minimum. Having failed to meet that bare minimum on the twin requirement of sufficiency of interest and being a aggrieved person, those two thresholds have not even been met. Now they want to even go to third floor before they even move to first floor. That's a very, very difficult thing to do unless you are Marcelin, which starts from the top coming down. But on the normal situation, you start from the ground, you go to first floor, second, and then you can reach the third floor.
Okay, let me hear now. Who comes next? The respondent? That's Mr.
Lordship.
You promised 3 minutes. I know you want to talk only for 1 minute now.
Yes. Having had the submissions by my colleagues, I will be brief.
You are supporting them?
I
Or you are
support,
the other side?
no, I support the PO. But we oppose the application for leave. In brief, the advocate for the applicant admits knowledge of the proceedings in 93 and 94. He has not explained to this court what novel issues is bringing before this court.
I was pleading before this court, by the way, for the petition. They are not, eh?
We had filed this before they were filed.
Yes, indeed.
Yes, indeed.
The replying update.
The pleading.
The extract of the prayers sought.
Okay, yes, continue.
We'll be relying on our replying affidavit shown by the Secretary to the Council, dated 15 April 2019. The applicant, having made no attempt to explain the novelty of this application for this court that distinguishes it from 93 and 94, having confirmed knowledge of the said proceedings. And in addition, having not stated any reasons for the delay in bringing this suit, confirming himself that the said decision was made on 11th of February 2019, are reasons enough for this court not to grant leave. In addition, he has not stated any prejudice that his client stands to suffer in the event that leave is not granted. Those are the main things I was expecting my senior to have expounded on in his submissions, other than going into the body of his application. In those humble submissions and in support of my colleague's submissions on the said issues, I beg to oppose the application.
Thank you. Who is next?
Just to point out, those pleadings appear in the replying affidavit of Professor Ojienda from page 79. That's what I pointed out, as the others prepare to respond. Submitted in the bottom.
Is it long?
It's like this.
Okay, the ones which are like that, one of them
It's filed on 15th of April.
okay.
The printed number is at the bottom. Page 78.
Yes, thank you.
More for the third interested party. Very briefly, the Lordship, we support the application request for leave,
You support?
the application seeking leave institute judicial review process.
So you're supporting Kinanji?
Yes. Primarily because first, the third interested party is a candidate in the election that is set to continue.
Yes.
And secondly, he has conformed and complied with the requirements that were sought. This is confirmed by the respondent's replying affidavit. And therefore, equality of the candidates meant that only the three met the threshold required by the Law Society. So in terms of there being a justiciable cause by the applicant to seek leave, we support that they actually are disclosing.
So you can grant the leave.
If we can grant the leave.
Your client is a candidate.
He is a candidate, the Lordship. Crucially, the Lordship, it is also our view that the requirements of leadership and integrity under the Constitution cannot be varied because they are constitutional requirements which the LSK imported into its code of conduct as shown on page 26. Even the AGM could purport to vary these, but these are not domestic rules. They were promulgated in order to adhere to the constitutional requirements. Now, on the issue of leave, we differ with the applicant because, in our view, it would amount to punishing the stay rather, it would amount to punishing the candidates who have complied.
So the stay you don't want it granted.
Unless it is restricted to those who do not meet the threshold. Yes,
So
that
you
is
support the leave, you force stay.
stay, and unless it is restricted to those who meet the threshold, and the third interested party, and the other two.
Stay to all of them. Those who met the threshold. Your client met the threshold.
Yes.
So you would mind in this state.
Our clients met the threshold. Those who did not meet the threshold do not participate in the election. That's a position, of course, we've also taken even in the other matters which we are not the ones who filed. But we believe it's an important matter because it touches on the integrity of the Judicial Service Commission, and it is not something. The discussion I've had here about arbitration, a constitutional matter cannot be referred for arbitration to undermine the constitutional requirements. Whoever is elected, if they don't meet the threshold, they'll struggle even to be admitted to the board. Most of them.
Are you through? I had many people in the court.
My Lord,
Remind me the name.
I'm Kiprono. I've been requested to hold brief for Mr. Karori for the sixth interested party, who is the president of the Law Society of Kenya.
So, Kiprono, what do you Karori for?
Sixth interested party, who is the president of the Law Society of Kenya. My instructions, my Lord, are that we do not hold a position.
You are neutral.
The sixth interested party do not hold a position in favor or against the application, and only to state that the sixth interested party is open to the court's determination on the issues. However, my Lord, on a personal perspective as a member of the Law Society of Kenya, I beg to draw the attention of the court that on 30th of May 2019, the members of the LSK made a unanimous decision, and all these issues are overtaken by events, and the court should exercise judicial restraint in determining all these issues.
So now you are taking two positions.
No, I am on record. Those are out of record. On the record, the 16th party does not take any or hold any position. But on a personal and out of record position.
No, it's okay, he has explained it.
Because on a personal, and I think Mr. Kinyanjui, who was not in the AGM, should not act personal.
No, it's okay now. Let me
You
go
have
with
no
it.
idea what about that. I had a personal issue.
Okay,
Thank you, Milo.
Are we through?
A lot for the ninth interesting.
Remind me the name. Are you also neutral?
Ninth interested party. I am not here for you.
Okay.
Your Lord, the ninth interested party is in full support for the preliminary objection and also opposes the application for leave. Associates herself fully with the submission of the respondent
The first interest voting.
and the first interested party.
Has the respondent spoken?
Yes, the respondent has spoken. Unless your lordship is forgot.
No, it's okay.
Yes. Your lordship.
But can you let candidates on the seat?
Your lordship, the ninth interested party filed grounds for opposition dated the 15th of April 2019.
Dated?
15th of April 2019.
Yes.
With the submissions dated 19th of April 2019. Your lordship, the reason why we need to exhaust other channels before this matter is before you is because if you look at even the statutory statement that is filed by the applicant, it's found at page 11 of the document. The applicant comes here as an advocate of the High Court of Kenya, and he says so. So he says, I have sound mind, I'm an advocate of the High Court of Kenya, and I'm a member of the first respondent, he needs to exhaust the mechanisms that are available. Your Honor, he has failed to show that he's an aggrieved party. And I will draw your attention to the definition of who an aggrieved party is. And we put next to our submission a definition by the 10th edition of the Black Law Dictionary. It says an aggrieved party is a person who has legal rights that are adversely affected. Your Lordship, it has not been shown to you that the applicant has legal rights, and that those legal rights have been adversely affected. That has not been shown. Your Lordship, the application for leave is meant to sift the process so that we avoid taking court time and filing frivolous, vexatious applications that abuse the court process and take its time. It is important to filter that at the right time before we take a lot of time. Your Lord, as I conclude, I refer to the case of Republic versus Kenyatta University ex parte, Ojienda Dominic, decided September 2018 by Justice Matigo, who I believe is deceased.
Which one is that?
Your Lordship, is annexed to our submissions. Is the only authority apart from
Okay, the reference?
the reference to the case, Your Lordship. It is Judicial Review Application number 201 of 2018. Your Lordship, this decision actually,
Was it an application for leave?
yes. And he said the ex parte applicants have not established any basis for the court to grant any of the orders. But the most important, what we are interested in this decision is that if you look at paragraph, starting from paragraph 43 to paragraph 48, it concentrates on alternative remedies and the exhaustion principle. And the court thinks that if the principles are not being exhausted, then there might not be need to offer them time to even say what they're supposed to say unless they exhaust those principles. The argument cannot be timed because they have always had time. I rest on that, Your Lordship.
Yes. Move it.
I don't want to brief for Mr. Makaka
For
the fifth interested
For Mr.
Makaka.
Maga. You are here from the beginning. For fifth, eh?
Fifth interested.
Yes.
On our part, we are relying on grounds of opposition and are replying affidavit. All dated 15 April 2019 and filed on
16 April 2019.
and filed in April 16.
Yes.
In addition, we'll be associating ourselves with the submissions by the first interested party as it regards to the local standing of the applicant in bringing the said application. In actual sense, we are opposed to the application dated 25th March 2018 and fully in support of the preliminary objection as raised. And since my senior colleagues have addressed most of the issues, I wish to rest my case.
Thank you. That was the last one. Mr. Ochiel. I thought you said you had nothing to say.
I have a few things to say.
For which party?
I appear for the 11th, 12th, and 14th interested parties.
12 and 14. And
Interested parties, and I hold brief for Mr. Kusala for the 7th, 15th, and 16th interested parties. Both Mr. Kusala and myself filed grounds of opposition. And we oppose the application for leave
and make the following 3 submissions. First, on the question of leave. Under Article 47 and 23, leave is no longer a mandatory requirement, and the reason is this: a party can file a petition, as the parties in petitions 93 and 94 have done, and get judicial review further. Those 2 petitions seek the exact same reliefs sought in this application, and no leave was sought. However, my lord, where a party files pleadings seeking leave, then they are bound by their pleadings, because that's a choice they've consciously made, and pleadings frame issues that the parties submit on and the court decides. My lord, that reading is consistent with Section 12 of the 6th Schedule to the Constitution and Section 12 of the FAA, which states that the FAA is not in derogation but addition to the principles of common law. So your pleadings, your choice. You choose to seek leave, you're bound to demonstrate grounds for granted leave. If it pleases the court, I'll turn to my second point, which is on the moot and academic principle. My lord, Shakespeare in King Lear says, nothing out of nothing comes. In law, this court's jurisdiction is animated by live controversy. The court has no jurisdiction to decide dead, hypothetical, or already determined controversies. And my lord, I've supplied the Evans-Kidero case, where my Lord Justice Mativo, at paragraph 6 to 9, holds that the appropriate reaction to a moot case, despite its pendency, is a dismissal. And that is because, my Lord, when the court determines a moot matter such as this one, then the court will be at worst giving legal advice, or at best rendering an advisory opinion. The court's determination would not have any practical effect. In this case, the substratum of the application has been overtaken by events for 2 reasons. The first is the AGM of 30th March 2019, which deleted that code. The code sought to be enforced in this proceeding. It doesn't exist. The second reason is that, if you look at the prayer for prohibition, the applicant seeks leave to prohibit that which has already occurred. He wants the respondent stopped from accepting the candidature of the first and fifth interested parties. He also seeks to stop them from participating as candidates. My Lord, when I was coming into court, one of them approached me for my vote. They were already participating. They've campaigned extensively throughout the country. So that the stable doors are sought to be locked long after the horse has bolted. The application, even before it was filed, was already overtaken by events. I now turn to my third and final point, my Lord, which is on the exhaustion doctrine. And the nobody disputes that the LSK regulations provide for arbitration of society disputes. Section 9 of the FAA, which is a normative derivative of Article 47, requires prior exhaustion. Well, that section has constitutional underpinning in Article 159, requiring this court to promote and not usurp alternative means of dispute resolution. So the ex parte applicant was bound to exhaust the option of arbitration. And Section 16 of the Judicial Service Act provides that the respondent should determine the issue of compliance of candidates. And that is the more reason why the ex parte applicant had to exhaust the mechanisms within the society. The policy consequence of failing to exhaust, my lord, is that the court is now faced with the nomination dispute in the first instance. My lord, for that submission, again I rely on the ex parte Centrica case, decided by my lord Justice Mativo. I've shared it with the court and with the authority.
Which one is that?
It's Kenya Revenue Authority, ex parte Centrica. It was an application for leave, and the court denied leave because alternative remedies had not been exhausted. But the party can apply for exemption. The two detached authorities, the first is LSK Prof, the other is ex parte Centrica. And that's paragraph all the way from paragraph 30 and at paragraph 35, 36, 37, 38, the court makes its determination. In that case, my lord, the court interprets the word shall in section 9 as mandatory.
And paragraph 28 of the judgment.
My lord, I already began by addressing the court on paragraphs 28 and 29. That was my first submission. Yes. That leave is not mandatory. Is not a mandatory prerequisite.
Is that what the paragraph says, or is what you submitted?
Yes, my lord. That we need to develop that aspect.
Yeah,
Consistent.
the court decision should boldly recognize the Constitution as the basis for judicial review. Judicial review is now a constitutional supervision of public authorities involving a challenge to the legal validity of the decision. Time has come for us to fully explore and develop the concept of judicial review in Kenya as a constitutional supervision of power and develop the law in this front. Courts must develop the judicial review jurisprudence alongside the mainstream theory of holistic interpretation of the Constitution. Judicial review is no longer a common law prerogative, but now constitutional principle, UPC. And those are just points.
Yes, my lord. I agree with my lord on that point and submitted that we need to develop that law by saying that a party can get jail without leave by filing a petition. The prayer sought in this application are sought in a petition in the next court. But where a party consciously decides to file an application for leave, then they're bound by their pleadings. And because the court cannot frame parties for cases, parties plead their cases the way they want. And not to the point I was about to make, if it may please you.
Yes, and you start on the reading. You
It's
have
on
taken more time now.
It's my final point, my lord, on exemption. If suppose the circumstances which make it impossible for a party to exhaust, then the party should apply for exemption. That ex parte applicant has not applied for exemption. Saying, for example, that the issues involved for the polycentricity. Again, the point made by my lord ex parte Centrica make it impossible or inappropriate to exhaust alternative remedies. That point has not been made before you. So we submit that there was an available, efficient, and effective alternative dispute resolution mechanism. It was available because it's open to the ex parte applicant. It's effective because it could resolve the issues. And it's efficient because arbitration is in fact more expeditious than court proceedings. So there was that alternative which has not been exhausted. And my lord, supposing that none of those things existed and the application was merited, the existence of parallel proceedings is a factor that the court will take into consideration in determining whether or not to grant leave. Because under Article 23, judicial review is discretionary. I rest on that point unless my lord has a question for me.
That's all.
Thank you, my lord. Unless you have a question for me.
No, not now. Let me spare the time. But that was the last one, I believe. Okay, please have a quick.
Yeah, and I have a quick rejoinder, my lord. I don't want to vex you with repetition.
You can even say no reply. Yes.
No, I'll just take very few minutes.
Okay.
Because some issues were raised. First of all, let's not lose sight of what your lordship has repeatedly pointed to council. We have the stage of leave. And you've asked a very important question. In Centrica decision, my lord, and in fact I was about to point out what you see in paragraph 28 of this Centrica decision. Is it time? You have the power, my lord. And my point to buttress that is this. There is a discriminatory effect that emerges now when judicial review is guaranteed under Article 23, and you can approach the court anyhow, even with a piece of paper, even someone in committee through a toilet paper can do so. But now my lot of friends are saying, if you go by judicial review, but what is the nature of proceeding envisaged under Article 22? Such is the proceeding. So really, as it were, we are now engaged in a technical aspect, which the Constitution in Article 22 has, as it were, shelved or rendered impotent. Therefore, to that extent, my lord, the arguments that we are bound, and I merge these with the issue of locking, or locus, the issue of so-called interest, to show we have an arguable case for leave. Secondly, my lord, none of the parties before you opposing this application contests that we have a marriage of the traditional judicial review and a constitutional argument. My friend Mr. Harvey brought to your attention that the appointment to the JSC male representative of the LSK is what is at heart in Article 171. And my learned friend went on to show that really what the dispute will surround be is that. So what happens, in my humble view, when there's that marriage of the traditional plus constitutional, then my lord, you have to relax the issue, leave. And this is such a case. The third point, my lord. My learned friends believe at the point of us seeking alternative remedy, and there was no prompt action. I take you back to the original exit, GMC. The president of the Law Society, when this grievance arose, he said he is going to take action. And then, my lord, it is not until then the decision was made that we were prompted to come before you. Who could we have avoided what the president then said from the Law Society? We couldn't in this so-called alternative dispute resolution issue. He is the one who took that decision. And so we were then moved based on that score. My second last point, I learned from Mr. Harvey saying that the issue is moot because, according to him, the decision of the AGM is in the same class as that of subsidiary legislation. Therefore, according to him, with respect, Section 28 of Cap 2 validates the retroactivity in respect of that decision. But we have two problems which allow my lord to intervene and to grant us leave. One, if that decision of the AGM is true and correct at face value to affect those nominations, they are null and void. Because then, if we don't have standards, as it were, set by the Electoral Code of Conduct, then everybody else is out there is eligible now, as we speak. Because these nominees were on set criteria based on that Electoral Code of Conduct. Now, if we say that the 30th of March then negated all of that, then the door is flung open. So you can see the reprobating and approbating argument that brings that into a conundrum of some sort. The second point arising from that, my lord, is that you have not been shown the decision at the AGM to say that this decision retroactivates. Let us not read into it, because nothing could have been much more deliberate than the respondents' AGM to state and decide we retroactivate this to the state nominations. In conclusion, we are at that stage in our growth of both jurisprudence, now what is sought in terms of the lead, and also our electoral process as the respondent, that we ought to align ourselves with a changed constitutional jurisprudence, which demands integrity and fairness to everybody. So if we say that some rules apply to some people in the JSC who are non-members of the respondent, and that they do not apply to some members of the male class of the JSC from the respondent, then we are perpetuating an unhappy Article 27 for discrimination. I rest my Lord, and I humbly request the grant of the peace. Thank you.